Um, First of all, just want to welcome everyone, and on behalf of your Baird Financial Advisor, very excited to welcome you to this month's Baird Wealth Strategies webinar. Our topic today is going to be focused on trust services. We're joined today by Corliss Taylor and Will Hobson, both trust strategists here at Baird. They're going to lead us through an informative discussion highlighting key trust solutions that could benefit some of the high net worth individuals. For those of you unfamiliar with Will works with Baird Financial Advisors and their clients, offering complex trust and estate planning guidance. Will has over 35 years of experience in trust and estate planning and administration. He is a member of Kentucky and the Kentucky and Louisville Bar Associations, as well as being a member of the Louisville Estate Planning Council. And for those of you unfamiliar with Corliss also serves as a trust strategist for Baird Trust. She comes to Baird after more than 16 years of banking, private wealth management, and trust and estate planning experience. She holds the Certified Trust and Fiduciary Advisor designation from the American Bankers Association. So before I turn the call over to them, just a few housekeeping items I'd like to highlight. For optimal viewing, we suggest setting your layout to the side-by-side view via the circle in the upper right-hand corner. All participants are in listen-only mode, but we'd love to hear from you. So we will host a Q&A session at the end of the call to address as many questions as time permits. You can submit a question by clicking the Q&A icon. Please be sure to address your questions to all panelists. That Q&A icon you should see in the bottom right-hand corner of your screen. This presentation is being recorded and will be available along with the slide deck through your Baird Financial about a week following today's call. So with that, would like to thank you for joining us today, and I'll now turn the call over to you, Corliss. The floor is yours.
Thank you, Corbin. And as you said, thank you to everyone who has joined us today. Will and I are so appreciative of your time as we talk through estate planning from beginners to boomers. So no matter where you find yourself, we thank you for joining us, and we hope that we have some information for just where you are in your estate planning journey. Today's agenda, here you are. What is an estate plan? We'll go over it. Types of estate plans, we'll discuss them. Using trust and estate plans, how do I do this? IRAs in estate plans, that is a topic that we get questions about quite a bit, so we'll go over that. About Baird Trust. After we've talked about estate planning, we'll give you a little bit of information about Baird Trust, our estate planning resources at Baird Trust, and how, if you so choose, to engage Baird Trust. And we really appreciate the opportunity to work with a financial advisor on engaging Baird Trust. And as you can see, no presentation would be complete without all the wonderful disclosures at the bottom. So please keep in mind that this information is for your informational purposes, but we're happy to discuss any questions at the end, as Corbin said. So let's jump right in. What is an estate plan? The question is, how do I get my assets, my belongings to the next generation, my beneficiaries? Well, an estate plan is that map that tells anyone that reads it how you want your personal and financial affairs to be handled. That is an estate plan. It is the process by which you want an individual or a family can arrange the transfer of assets in anticipation of death or incapacity. You've seen some of the stories in the headlines where an estate plan had not been created, and some of the challenges that beneficiaries, heirs, those who are to receive the financial assets or the personal assets had to go through just to get the assets to their hands. So if an estate plan is the map, what types of estate plans can I put in place may be the next logical question. So there are three types that we want to cover today: intestacy, contractual planning, and of course, proactive estate planning, which Will and I think would be in your best interest to consider. Proactive, get in front of putting a map in place, outlining the process by which you want your personal and financial affairs to be handled. So let's look at the first one. What is intestacy? It is the state or condition of dying without having disposed of all or a part of your property by a last will and testament or some other type of arrangement. In other words, you did not put this process of this plan in place. You did not memorialize it in a document. So if you don't have one, you die intestate, as we call it. Your state legislator will have one for you. What do I mean? There are some state statutes out there in every state. They've outlined exactly what happens if you do not put your estate plan in place. We use Kentucky here to just give you an example of intestate succession. This is when a person dies without having memorialized their information or their wishes. Kentucky is where Baird Trust has its headquarters. So if we look at the state statutes, as we call them, statutorily imposed estate plan, here's what you have. If you don't say, I want my child or children to inherit, and you have a spouse and you do have children, then here's how the state of Kentucky says. If you look at that second line item, you have a spouse and children. Half of the personal property goes to the spouse and half of your real property to the spouse. And then the balance is split evenly amongst children. And you can see the chart here. If you have no children, but if you have children, no spouse, the entire estate goes to children. But you may want some nuances in your estate plan. That's why we want to encourage you to think about, talk to your financial advisor about how do you put an estate plan in place to effectively execute on your wishes. But if you don't, your respective state does have a statutorily imposed estate plan, which is why we want you to consider being proactive. Contractual estate planning, that's the second point. Estate planning on an asset by asset method based on a contract between you, the owner, or whoever owns that asset, and other parties, your beneficiaries. So examples include, so you'll understand what contractual estate planning is, accounts held jointly. My name and my spouse's name are on the account, so we both own it by that contract that we're co-owners, joint owners on that checking account, savings account, or payable on or transfer on death accounts. You can put that information on your account, typically a checking account, savings account, and say, upon death, this is the person to whom I want the money to go to, the assets to transfer to. Retirement plans, beneficiary designation forms, I am sure if you have an IRA, your financial advisor has asked you for this, and if it changes, they have gotten the information updated. So retirement plans, IRAs with your named beneficiaries are contractual estate planning methods. And then finally, we have here as an example, insurance policies and annuity contracts. You have to name who the beneficiaries are for that particular asset. And if it changes over time, your contract can be revised. As long as you are alive and competent, you can make changes to your contractual estate planning. A last will and testament, another type of planning. This is a document, and I'm sure you've heard of it. Most people just say the will. A last will and testament is the document that directs. It directs the disposition of your estate after death. So you would draft a document and then execute by signing, making it official. Well, each state has a protocol that must be followed in order to have an effective last will and testament. Again, in the state of Kentucky, the state says age 18 or older, age of majority, testamentary capacity, you have to be competent, you have to sign, and there must be 2 witnesses to that last will and testament. And then usually the will address key points in your estate plan. Who is the responsible party to oversee this process? When you are settling an estate, who is the personal representative? You've heard executor, personal representative. Those 2 words are interchangeable. Who will be the person or the entity responsible for settling your estate? Who will pay the debts that are owed from your estate, the taxes, the financial obligations, and even the ultimate correct distribution or disposition of your assets. How do I give 1/8 to this beneficiary and 3/8 to this one? The person is usually, or the entity is named in that last will and testament. And then please be aware that the will, last will and testament, must go through the probate process to be effective. It must. It is a public document that is probated upon the death of the individual that drafted. And in each state is different. Be aware of this. Each state is different, and you should consult with your estate planning attorney to understand the state statutes or the laws of your state to make sure you are drafting your last will and testament according to the wishes that you have for your assets. So I'll give this over to Will to give you an example.
Thanks, Corliss. I appreciate it. I also appreciate the opportunity to talk to everybody today. This is the first time since Baird acquired the trust company that I've had a chance to address our clients on a major basis, and I really appreciate the opportunity. The slide you see right here, we developed basically after a few years of managing estates, and I think it's helpful to sort of visualize what exactly happens in the estate planning process after a person passes away. And in this example, I'm using a husband and a wife. And in my example, I kill off the husband first. Not that I have anything against husbands, I'm one myself, but statistically, we're the first to go. So the husband's passed away, and the wife has come to us and asked for help with the estate administration process. And we usually find 5 asset classes. We find a certain amount of assets that are simply in the husband's sole name. We find that the husband and wife owned assets subject to some sort of contract. They might have a bank account. There's a contract between the husband and the wife with the bank that says at one death, the husband's or the wife's, the bank has to give that account solely to the surviving co-owner. We find that. We also find transfer on death, as Corliss mentioned, or other assets subject to some form of contract. We'll usually find a pile of assets that are retirement assets in the husband's name. And then, of course, we find that the wife has assets in her name and the wife has retirement assets. When we go through this process, after the first death, these 5 asset classes in a typical estate plan become 2 asset classes. The husband's assets, if the will says that everything is left to his surviving spouse, the husband's assets go through the probate process and become the wife's assets. The jointly held assets, the TOD assets, the payable on death assets, they become the wife's assets subject to the terms of the contract. In a husband's retirement plan, if he's named his wife as the beneficiary of that retirement plan, she can simply roll the assets in the retirement plan into her own retirement plan. So we go from 5 asset classes down to 2. Now, when the surviving spouse passes away, we've only got these 2 assets. Her will control what is going to happen to those assets. At the first death, we rarely see any estate taxes at all. Transfers between husbands and wives are tax exempt for federal purposes, and as far as I know, for every state purposes. You can leave your spouse $1, you can leave your spouse $100 gazillion, and there's no estate tax. But that's not the same story when the surviving spouse passes away. Currently, right now, there is no federal estate tax if the total estate is less than $12,920,000. If the total estate exceeds $12,920,000, there's a 40% tax on the excess. But when the surviving spouse passes away, we're going to look at her will. We have to take her will to probate court. The court will pass judgment on everything, and the assets will eventually be distributed to the heirs that she has named. The assets in her retirement plan will also be designated, will be distributed to the beneficiaries that she has designated, but that passes outside the probate process. That's a contractual arrangement. The will doesn't control that at all. And Corliss, I think you're taking the next section.
Yes, thank you. That was such a good example, Will. You do a great job with that, explaining the different levels. But so now we've talked about the last will and testament. Remember, it's all about estate planning from beginners to boom to those that are boomers. How do we get our assets, our financial assets, our personal assets to our beneficiaries? A trust can also be used in an estate plan. A trust is simply a fiduciary arrangement, a document that allows a third party, individual, or a corporate trustee to hold those assets that you have on your behalf for your beneficiaries so they may inherit those as well. Now, the contractual ownership arrangements include terms like this to control the business and personal financial affairs. Remember, the second point was contractual estate planning. This, a trust document, is contractual, and you get to say what is in the document. Yes, I have a business. This is how I want it governed, or personal affairs. Control abuse or loss of assets by heirs. In other words, put specific instructions on how you want monies or assets to be given to the heirs. Provide for a disabled heir. You've heard about special needs trust. You want to save on taxes, drafting the trust accordingly, and avoid probate. You have heard the word probate quite a bit. We said the last will and testament has to be probated. Probate is simply defined as a court supervised proceeding that authenticates your will, if applicable, and approves your named executor so he or she can distribute your property and belongings. So, yes, you want to consider who you put in that last will and testament because it will be probated, and then you can draft a trust to actually help you to avoid probate for your other assets. Dovetailing from that point, a trust can be either revocable or irrevocable. Standard revocable trust is created by you, the trustee. Typically, when you create a trust, you are the trustee. You can name someone else, but typically the creator is the trustee. It benefits you as the creator and your spouse, typically. And then you have successor trustees named in the document so that upon your death or incapacity, disability, someone can take over that roadmap that you put in place. A revocable trust is fully amendable and you can make changes. You own the assets, so therefore you can make changes. And so, Will, I can give this over to you to talk about why to even consider a revocable trust.
Sure. Yeah. Thanks, Corliss.
Mhm.
Yeah. To me, a revocable trust is a terrific tool, basically because of the probate avoidance. Uh, you have to have a probate proceeding. Your will has to be approved in every state in which you own real estate. I happen to live in Kentucky, and we apparently work with a lot of wimpy people because these people have for years have lived basically in Kentucky, but it's cold here in the winter, and so they have a place down in Florida or South Carolina. And then it's hot here in the summer. It's terrible out there right now, awfully muggy. Well, these wimpy people can't stand that. So they trot off to Lake Michigan and they have a lovely place on Lake Michigan. They own real estate in 3 different states. When a person who owns real estate in 3 different states passes away, we have to have 3 separate probate proceedings, one in each state. That's expensive, that's complicated. Uh, there are privacy considerations. A will is made a matter of public record, as Corliss mentioned. Anybody can go into probate court and get a copy of a person's will. This is a print or an outline of what you want to see happen when you pass away. But do you really want your neighbors knowing about this? If a kid's been through a nasty divorce, do you really want your drunken ex-son-in-law or grasping ex-daughter-in-law to be able to go to court and find out how your child inherited assets? This problem is very pervasive, particularly. And this is one of the things that surprised me. I learned it actually while I was still in law school. The smaller the town is, the more likely it is that a person's will is a matter of not just public record, but public knowledge. It's very easy in a small town to go to the probate clerk's office and get a copy of a will. I've actually seen people photocopy copies of wills and hand them out for everybody to read. To me, that's nobody else's business. You also, when you go through a probate process, an inventory of the assets of the estate must be filed with the court. This is a pretty detailed inventory, and it too becomes a matter of public record. People can go into court and find out what your house is valued for. People can go into court and find out how many shares of General Electric you own. People can go into court and find out if you owned interests in a closely held corporation. All of this stuff becomes a matter of public record. And really, it's nobody else's business but yours. But that's what the probate process is. Corliss, would you advance the slide? This public proceeding thing really, to me, is a big reason for not going through the probate process. We've had a situation that it sort of just rang home for me. It was in South Carolina. There was a very wealthy old gentleman over there. He lived a pretty quiet life. I don't think anybody in town had any idea that he had any money, but he owned something like 8 gas stations. Nobody knew that until he died. All of a sudden, they showed up in the inventory, and his daughter was hit with lawsuits. People were saying, "Oh, I fell down in the gas station," or "the gas was bad," or this or that or the other. They weren't going to sue him until they knew he had all this stuff, and the only way they knew was this inventory for the probate process. So it's a great thing to try to avoid probate. Probate is also time consuming. It takes a while to do this. The probate proceeding is there really to protect your creditors. When you pass away, before you can distribute your assets, or before your assets can be distributed to your heirs, the government has set up a structure, this probate process, that allows your creditors to go into probate court and say, "Hey, the deceased person owed me some money. I want to collect on it." And they give those people something like 6 months in the case of Kentucky. It varies from state to state, but there is a time period that the estate is open so the creditors can come in and file their claims. So it takes a while. The judge will not close this probate process down until the expiration of that period. And it may be that it's going to go longer than that, because if there's been a federal estate tax return that needs to be filed, the estate can't be closed until that's been filed and approved, and that takes a couple of years nowadays. There are costs associated with this. There are court costs, filing fees. They can be hundreds of dollars now. Attorney's fees. When I got out of law school, attorneys around here were typically charging 5% of the value of the estate for probate. They don't do that anymore for the most part. Most people are charging by the hour. But at that time, before revocable trusts, attorneys were really seeing this as a cash cow. If you're willing to go through the probate process, I would suggest you talk to your attorney about how he or she is going to charge their fees, because it can be a terribly, terribly expensive process.
Absolutely. That's such a good point. I have to throw this in. When I was in law school, there was a case where a woman did not want to have anything to do with her father, nothing. She was, for whatever reasons, growing up, he wasn't there, she was done. And he did not have an estate plan. So his will, he had a will, it went through probate. When she realized how much he was worth, and she was his sole heir, she loved her dad after that. He was the best father ever. So you might want to put your estate plan in place so that you can say how you want your financial affairs and your personal belongings to be distributed. So be aware who is named. Your documents, once you put this in place, you need to review them. Who is named at death? The trust principal remaining is to be paid to the owner's estate. Your personal representative or your executor, those words are used interchangeably, will be the person that's handling, or the entity that's handling this. Who did you put in that position? If you typically they tell us if you go laterally, statistically, someone like a sibling, a best friend, may pass or become incapacitated around the same time as the owner of these assets. So you may want to consider carefully who you are putting. If you have to, in these positions, if you have to go to a child, then are they responsible? If you're using a corporation, do they have a good history? Have they been around for a while? Be aware of who you name to handle this plan that you have put in place. And then unfunded trust.
Hey,
You
Corliss,
have,
can I
yeah,
jump in for just a second?
sure,
Uh,
absolutely, please.
One of the things that I think this paragraph is also addressing is some of the older trusts that are out there where at a person's death, they created a revocable trust that was designed to take care of them during their lifetime. But it was set up so that when that person passes away, the assets were distributed according to his or her last will and testament. That doesn't help you avoid probate, that ensures probate. Your trust should specify where your assets are supposed to go when you pass away. Have a destination for those things other than your estate, which would ensure a probate process.
That is a great way to look at that as well, Will. Absolutely. I've seen that in a case that we had that the information was omitted, what we call silent. And all the assets, then all of them, where the client had diligently put this in place, did not effectively name where it was the assets were to go. And it just unwound it, just like you said. And it took years to work that through because intent was there, but the document did not state it specifically. You're right. Thank you. And then unfunded trust, and please feel free to jump in, Will. An unfunded trust, I have seen this in practice as well, where all the owner has created this revocable trust, a trust that can be changed. The owner had wanted to avoid probate, just like Will has told us about it, and then the assets are not titled correctly. You didn't title the asset in the name of the trust. So now the trust doesn't have any assets. These assets, to Will's point, will go through probate. And Will, you had a great example of this about not going unfunded trust.
We sadly, I've been associated, I've been in the securities industry with estate planning since 1990, and this happens over and over again. A family, a person has passed away. The family comes into the financial advisor's office and they're so excited after the death. They're sure they're sad about the loss of the loved one, everything, but they're holding a revocable trust. They found it in the nightstand. And they go to the financial advisor and say, well, hot dog, we don't have to go through probate because we've got this revocable trust. And the financial advisor says, well, gee, let's check out the record. The financial advisor looks on the books. All of the assets in the client's name are held in the client's name. They're not owned by the revocable trust. If they're not owned by the revocable trust, they're subject to the probate process. It would have been so easy for the client to given a copy of that trust to the financial advisor, and the financial advisor had changed the name on those assets from the individual's name to the individual's trust with the individual as trustee. The individual still would have been in total control. Nobody could tell the individual what to do, but probate would be avoided. And this happens, my goodness, I would say around here, it happens 2 or 3 times a year that the trusts just are not completely funded as they should be.
Yeah, so it can be avoided by simply reviewing and making sure you get the deed done or deed updated or whatever the asset is, title it correctly. Irrevocable trust. An irrevocable trust is simply one where you created and you cannot make any changes once you've drafted that document. You can't change it or end the trust after its formation. So typically this is the creator of an irrevocable trust. Irrevocable trust wants to either make a gift to someone, get those assets out of their estate, or they're looking to maximize some tax benefits, reducing their taxable estate, attach strings to a gift. Here, these assets are in this particular account, and here's the document that governs this irrevocable trust. And in this document, I can say, you can have this money if, you can have this money when, putting a string on it to make sure the assets go to the beneficiaries according to the wishes of the creator. And then you can shield assets from creditors by putting assets in an irrevocable trust and dictating the terms of the document. But you cannot make any changes to this trust once it's created or unwinded. Now, sure, maybe you can go through the court process and it's arduous. It could be drug out, cost, all of that. So think really carefully about the planning that you put in place if you draft an irrevocable trust, because typically it's where you cannot make any changes or in the trust. And Will, I'll give this over to you.
Okay. Um, I think a revocable trust is a terrific tool. The revocable trust helps you avoid probate. The revocable trust helps you maintain privacy. The revocable trust can be drafted. We really haven't hit on this, but the revocable trust can be drafted in a way that if you become incapacitated, it can spell out how you'd like to be cared for in the event of that incapacity. I've actually seen revocable trusts that specifically say the trustee cannot place the trust creator in a specific nursing home because that person had some issues with that nursing home. You can be very detailed in this respect. But I also, while I think the revocable trust is a terrific tool for estate planning purposes, if you have a revocable trust, I think it's a very good idea to also have a simple last will and testament. This simple last will and testament serves as a safety net. There are times, even with the most carefully crafted revocable trust, that assets get left out of that revocable trust at the time of death. Your last will and testament can serve as a safety net to gather those assets and say at the time of death, the will specifies that those assets will be left to the revocable trust. Now, the will go to probate court. One case we had recently, there was a $15,000 checking account that was not in the name of the trust. We had to go to probate court for that $15,000 checking account, but the will simply left it to the trust. So we had an executor appointed, the executor transferred it to the trust. If anybody wanted to go to probate court and read that will and look up the inventory and see that $15,000 account, they could do so, but that's all they see. The trust is not made a matter of public record. If they want to find out more information, they've hit a brick wall. The will is just there as a safety net, and it does that. It moves the assets into the trust. So at death, a typical process. In a typical process, as I mentioned before, we find the 4 asset classes, and sometimes we'll have a trust as an asset class that will avoid probate. We have to determine what assets are there, which assets fall in which asset class, and whether a probate is even needed. Then we use the will as a safety net to get those assets into the trust.
That's great. And then the objective is absolutely to avoid probate if you can. And it's not so much that probate is bad. If you have to go, please don't feel like, oh, I did not draft my estate plan correctly. If this has, but the objective is get everything flowing smoothly so that it can go into your trust account so all your beneficiaries can receive the assets and the personal belongings that you wanted to get to them. So we're getting ready to talk about IRAs and estate planning, and we'll talk through this. This is typically the area where we see a lot of questions. You know, you've heard about the Secure Act, but here, if the chart will explain exactly what happens with all these terms that are thrown out, non-designated beneficiary, designated beneficiary, but Will is excellent about covering this. So Will, I'll give this to you.
Well, thanks, Corliss, and we'll see how excellent I am. This is a pretty crazy area. IRAs are wonderful tools. They're a great way for assets to grow tax-free, but the government has its sights on them. The government wants to collect that uncollected income tax inside those assets. And a few years ago, the government changed the way a person's IRA is taxed after that person passes away. Traditionally, if I had an IRA and I passed away and I named my child as the beneficiary of that IRA, my child was allowed to withdraw the assets in that IRA over a period determined by the child's age. Sounds kind of nuts, but let's just say a 45-year-old inherited an IRA. The 45-year-old could go to the bank and say, okay, I want all that IRA right now. In that case, the IRA, all of those proceeds would be dumped into that person's income tax obligation for that year, and you'd pay a whopping income tax. If that person had any sense, they would have said, well, how can I defer paying that income tax? Prior to the recent changes, a 45-year-old had something like a 40-year period to withdraw the assets in that IRA. And the way the government worked it out was the first year after death, the 45-year-old took 1/40th. And then the next year, 1/39th. And then the next year, 1/38th, and 1/37th, and so on and so forth. And finally, by the time the beneficiary reached the age of 84 or 85, they'd pulled everything out. But they only had to take that fraction out, and the rest of the IRA was growing income tax free. This was a great way to put off paying taxes. And Congress got a little upset over that a few years ago. They argued that an IRA is not an estate planning tool, it's a retirement planning tool. And they basically put an end to the party of sorts by not allowing us this lifetime expectancy for most heirs to receive their benefits. It's a 10-year rule for most people, but not for everybody. So let's go through the chart. Actually, up here in the left-hand corner, charities, if you designate a charity as the beneficiary of your IRA, you have designated the best possible beneficiary. If a charity receives an IRA, one, it's out of your estate for estate tax purposes. Gifts to charity are not taxed for estate or inheritance tax purposes. So you've saved some money there. And the other thing is a charity doesn't have to pay income taxes. So if a charity gets an IRA, $10 or $10 million, they get that whole IRA. They don't pay any income tax on it. If a child gets it and it's dumped on top of the child's income, it could throw the child into higher income tax brackets. The child's only getting cents on the dollar. But the charity is really the absolute best beneficiary for an IRA. And if anyone is charitably inclined, I suggest that they talk to their attorney about arranging things so that they don't leave charity money in a trust or in their will. If they've got a retirement plan, the charitable dollars should come out of the retirement plan rather than after-tax dollars. Another thing that people do, though, and this is the block where it says estate and will, no designation. If I have designated my estate as the beneficiary of my IRA, or if I've just left a blank for the beneficiary of my IRA, if I just don't bother to do anything at all, the government says that I have no beneficiary designation at all. And the government's going to force the income taxes to be paid in a very short period. If I die before I'm 73, those income taxes have to be paid by whoever ends up with that IRA within a 5-year period. If I'm over the age of 73, the government will let whoever owns that IRA after my death pay the tax over an extended period. And this is where it really gets crazy. The government says that the person that has inherited that IRA is allowed to pay the tax over the remainder of my life expectancy. Well, it's my IRA, but I'm dead, so I have no life expectancy. That doesn't bother the government at all. The government says, okay, Will was 73. He passed away. He had a life expectancy of like 10 years. So that beneficiary could take it out 1/10, 1/9, 1/8, and so forth. But that's the best they can get. And in most cases, it's very, very inconvenient. Then the new act, though, has placed some real limitations on here. Now, there are no limitations for certain people. If I make my wife the beneficiary of my retirement plan, then she has several opportunities, and she doesn't have to fool with the 10-year rule if she doesn't want to. If I name my minor child as the beneficiary of an IRA, that child is allowed to defer income taxes over the child's life expectancy until the child reaches the age of 21. And then everything has to be paid within 10 years. So all of the income taxes will be paid by the time the child is 31. If I have a disabled beneficiary or a chronically ill beneficiary, that beneficiary is allowed to use his or her life expectancy to pull IRA beneficiary or IRA minimum distributions out. But there's a real conundrum there, and I urge you to be very careful and talk to your estate planning professional about naming a chronically ill or disabled person as the beneficiary of an IRA. Because if that person is dependent upon Medicaid or Social Security payments, and all of a sudden there's more money coming in because they have to take distributions from an inherited IRA, it may disqualify them for Medicaid or Social Security purposes. So this is something that really needs to be worked out closely with your attorney. Also, if I've named a beneficiary as a beneficiary of my IRA, a person who is less than 10 years younger than I am, who's 9 years younger than I am, say, that person is allowed to use their life expectancy because they assume that person is so close to me in age, they're not going to live much longer than I was going to live anyway. So the government lets them do that. All of the other beneficiaries, though, are now limited to a 10-year period. And I really like this bullet point on the right-hand side in the middle block, minor grandchildren of owner. The only minors that get to extend an IRA over their life expectancy until they're age 21 are the actual children of the owner, the original owner of the IRA. Grandchildren don't count. They're going to be subject to the 10-year rule, even if they're 1 year old, 2 years old. Let's move on to the next slide. And we can talk a little bit more about the spouse. If a spouse is named as the beneficiary, the spouse has several options. The spouse can treat this as a rollover. Basically, it just becomes the spouse's IRA. Now, if the spouse does that, the spouse is not able to take anything out until he or she reaches age 59 and a half, because it's his or her IRA. That's the way an IRA works. You can't take anything out without a penalty until you reach 59 and a half. So it's something to think about. A spouse can also treat it as an inherited IRA, and that lets them take it out over a much longer period. But they also don't get to reset the clock when the beneficiary's passed away. Let's go on to the next slide. This is the one that's where it's gotten pretty interesting. If I have named a child, an adult child, as a beneficiary of my IRA, and I pass away before I've reached the required beginning date, that's April 1 of the year after I turn 72, that person, my beneficiary, has a 10-year period to pay the tax on that IRA. And that person can do it any way he or she wants to. They can start taking it. They can walk into the bank the day after my death and take every penny out of that IRA. Then they're going to pay the income tax on it all at once. A typical scenario probably would be that they take 1/10 in 1 year, 1/9 in 1 year, 1/8 in 1 year, 1/7, and so forth. Or they can wait the full 10 years and at the very last minute go out and take everything out. Go in there and take everything out. That's let everything grow tax-free for 10 years, but it also means there's going to be a whopping tax bite at the end of the 10-year period. What we see most people doing is sort of hedging their bets. If a person has inherited an IRA and they don't have to take anything out of that IRA until 10 years after death, and they have a year that their income's real low, they might want to go in and take extra distributions from the IRA to bring them up next to the next highest tax bracket, just to sort of play the odds there and lower those that tax responsibility. Likewise, in years that they have income, a lot of income from another source, they might not want to take anything out of the IRA, push it back until that 10-year period is up. If I pass away and I've named someone as the beneficiary of my IRA and I die after April 1st of the year after I turn 72, that person has to start taking distributions. They are not allowed to just ignore everything for 10 years. They have to start taking distributions the year after I pass away. And that distribution is based on that person's life expectancy. They can always take more than that, but they can't take less than that. So if it's a 45-year-old person and that person has a 40-year life expectancy, the year after my death, the first they have to take out, the first distribution they have to take out is 1/40th of the IRA. They can always take more, they just can't take any less. The next year they'd take 1/39th, they can take more, they just can't take any less. And then by the 10th year after my death, they have to take everything out. This is sort of an example of what that might look like. And in this case, all right, 45-year-old, I thought they had a 40-year life expectancy, 32.59. I'm sorry. I'm being very optimistic for the 45-year-olds out there. But you can see how it works. They have to take a portion of the IRA. In this case, we said the IRA was worth 500,000. We divide 500,000 by that person's life expectancy, 32.59 years, and we see that the person only has to take a distribution of 15,342. Now, if the IRA is growing at 8%, the IRA is growing at an amount greater than the distribution, so we are still sheltering assets from income tax. So it makes sense to do this, unless, of course, the 45-year-old really has to have the money early. But this could actually let it defer until year 10, when the remaining balance is going to fly in. And that's going to be a rough income tax year for that particular beneficiary.
Very good information, Will. I want to highlight, just like Will gave the beneficiary 40 years, we're giving them this hypothetical 8% growth. It could be negative returns. So please
Sure.
keep that in mind. This is just an example. But in a perfect world, this is exactly what would happen. The non-spouse as a beneficiary, as Will explain, you got the 10-year rule, but how they take the distributions, they have to take this flat amount, whatever that number is that's required, but then they can make some machinations to it according to the income that they receive that year and all of this. This is great information to know as you think about putting an IRA in your estate plan. Very detailed information. So the trust as a beneficiary, you can have a spousal trust or family trust. Typically it's called AB planning, Will, a family credit shelter. And the reason you want to think about a spousal trust is because you may have a spouse that may not know how to handle money, assets. The credit shelter, you still have some credit shelter provisions, the consumption of that credit shelter going into the spousal trust and to use it up. Or you could be in a second, third, fourth marriage situation where you want to put some parameters around what happens into those assets. And then the survivor could remarry, be sued, be exposed to liability risk. And the family trust does the same thing. It protects against irresponsibility, whatever that names itself, however it manifests itself, claims from spouses, ex-spouses, creditors, stretching the provisions. These are some of the estate planning techniques that you can use to effectively get your assets to your beneficiaries. Now, we've talked about it. We'll have some great examples. Hopefully, it's coming into a clear view of what an estate plan can do. And we just wanted to give you a little bit of information about Baird Trust. Will and I are trust strategists, as Corbin said at the top of this call, and we work for Baird Trust. And we were founded in 1984, so we've been around quite a few years. We are headquartered in Kentucky, hence the reason we use the intestate laws from Kentucky. But we also have offices in Cincinnati, Evansville, Nashville, Greenville, and Milwaukee. About 19.5, 0.8, right at 20 billion in assets as of last year, and still growing, over 90 associates. And the reason we're telling you this is because at Baird Trust, we have a history. We're great corporate trustee in our opinion, but we keep the financial advisor as the main focus of relationships. So about this estate plan, you put an estate plan in place, you decide who you want to execute on that estate plan. But if you considered Baird Trust, you would talk to your financial advisor about it, because we, Baird Trust, Will and I, our colleagues, we all work with the financial advisor to make sure that they're the focus of the relationship, whether they're using our full service channel or whether they're using our directed trust, whatever it may be. We continue to look to the financial advisor because they're your point of contact. And Baird Trust continues to work with what we call your centers of influence, the people that you work with, your estate planning attorney, your CPA. That's how we govern ourselves at Baird Trust. And if you wanted to learn more about us, how we are structured, what we do, who we serve, and how Baird Trust came about being, our history and where we are now, BairdTrust.com is a resource for you to explore. Lots of great information out there from our marketing team. They've done a great job to just really explain who we are and what we do. And remember, again, we can't say it enough, the financial advisor is the main focus of the relationship. And you can work with all of us. We have a host of associates, strategists, officers, estate settlement to work with you regarding your estate plan, because we know you're going to go after Will has talked and after we've talked, we know you're going to go out and talk to your estate planning attorney about what you can do to execute on a will. So again, thank you so much for joining us. We appreciate it. It is our pleasure to actually talk about what we do to you, and you joined us. So we're going to turn it over to Corbin and see if we had any questions, anything we need to go over. Thank you so much.
Thank you, Corliss. Will, thank you as well. Really appreciate you sharing your expertise here. Before we begin with the first question, just want to take a moment and remind everyone that you can ask a question via the Q&A chat in the bottom right-hand corner of your screen. Please just make sure that you address questions to all panelists. I see that we have had a few come in here throughout the call. So Corliss, Will, if you're able to open up your Q&A, is there a question that you'd like to start with?
Well, Corliss, I don't know how to do that, so you're going to have to jump on that.
That's funny. So we love what we do, but sometimes technology. So here, we will, once we have compliance, like we said, with the slide that had the disclosures on it. Once we finish getting our compliance team to review the slides and the video, we will have a link sent out to the financial advisors, sent out to those of you that join, so that you can review this presentation and go over it and think through if this is something you would like to engage in. And let's see, what else do we have? Okay, mine went away. Corbin, I don't have them either.
Yeah, I can maybe read out. Let's see here.
I got it. Thank you.
You got it? Okay.
Well, I got it. So,
All right.
yes.
Well, you know what? Maybe I know how to do it too.
If you click on Q&A, so we want to make sure we're answering these. I have it. Okay. You will get the slides in addition to the video. Thank you so much for asking for it. We will get it out to you. If you have your trust set up and you're grandfathered in, if the rules change, am I correct in saying if I know I am about to expire, pass, if I make can I make changes to my trust? If you still have capacity, you can make changes to your trust. If it's a revocable trust, remember, an irrevocable trust, if you drafted that, you can no longer make changes. But as long as you're alive and competent, you can make changes to your trust, even if you have an illness. Absolutely. Sometimes we see when people have an illness, they think about estate planning, and that's when they draft it, but they're competent enough to be able to say.
I can take the question about common law marriage.
Oh, absolutely. Thank you.
Yeah, and I'm kind of interested in it just because of the question came up recently. If you're not legally married, you've been living with somebody for a long time, you've been basically living as husband and wife, but you're not legally married. In some states, it is possible for this to be recognized as what's called a common law marriage, but not all states recognize common law marriage. I'm in Kentucky. We don't recognize common law marriage unless the marriage at one point took place, or the relationship took place in a state that does recognize common law marriage. So I would not rely on hoping that your state will rely on common law marriage. If you're in a relationship with someone, you basically consider yourself to be married to that person, but you never bothered to go through the legal process. You need to talk to an attorney as soon as possible for help crafting your estate plan, because there are tax ramifications here as well as ownership ramifications. In my state that does not recognize common law marriage, I could have been living with the most wonderful woman in the world for 50 years. We could have children together. But if I don't have a will leaving everything specifically to her, my state would not recognize her as my wife. At my death, everything I own would be given to my children, and she would be totally out. So I strongly suggest that people who are in that situation talk to an estate planning attorney about getting things set up so that you can avoid taxes and make sure that everybody is taken care of the way you want them to be.
Excellent. What sort of situation would it be beneficial to have a spendthrift trust? A spendthrift is language in a document that says, this is what I want to happen with these assets, and no, Corliss can't have them all just because she wants to go on a shopping spree in Milan. You want to make sure that these assets are protected, so you put language in your document to make sure the beneficiary doesn't get them, creditors can't penetrate, and you cover someone who is not financially savvy. An example is we had someone who thought that the trust was just their checkbook, and it is not. So you know what's the situation you should think about? Who are the beneficiaries that will be the recipients of your assets? And do they know how to handle these? If they don't, you want to make sure that you put language in the document that will help guide them and keep this money where it can be elongated over the life of that beneficiary and not just spent in what could be frivolous manners or could be with someone else that is asking them to get money from the trust. You want that language in the document so the trustee can make sure they are governing themselves accordingly. And then I see very good point about the probate process. What is the probate process? You say avoid it, but then you say the will has to go through probate. A last will and testament has to go through probate to be effective. But as Will explained, you want to title your assets in the name of a trust so that assets go to the trust account and not have to go to the court where everyone can see those assets. Trusts are private, and that's what helps you to avoid probate by having your assets properly titled. You own, the example Will gave was you own real estate property in 3 different states. Have all 3 of them titled correctly in the name of your trust account so that when you pass, that asset will actually go to the trust and not have to be exposed in the court where you are, the state where you are.
And Corliss, there's a question about houses and autos in trust. Your house definitely could be, it's a simple deed from yourself as an individual to yourself as trustee of your trust. And again, I can't hammer home enough the importance of doing that for real estate owned across state lines. For automobiles in trust, that if you have a really expensive automobile that will certainly trigger a probate process, then yes, it should be titled in the name of the trust. There are going to be county clerks out there who are going to be reluctant to do that just because they don't understand what's going on, but they can do it. It can be done. You may have to sit on them, but it can be done. But most states do have a de minimis probate process. If you've got an old car that's worth less than $1,000, I don't know that I'd worry about putting that in trust. Just junk it before you die, or own a joint with rights of survivorship. But there's also a de minimis probate process in most states that would allow an asset that's not worth a lot of money to slip outside the probate process. It does involve a trip to court, though. Not necessarily standing before the judge, but usually filing something with the clerk.
Mm-hmm. Beneficiary designations, we have that question, an IRA or insurance contract. If you have a beneficiary designation on file, that's where the assets will go. So it goes directly to that person that you know, persons that you've named in your beneficiary designation form. It's a contractual agreement, so it goes from Corliss to Will. No other stops, directly to Will, doesn't have to go through probate. And I know we're at time. I think this is a great way. Will, please feel free to jump in with any other questions. But I see a couple of questions here. You know, what are your thoughts about the exemption going away? And what I think that's a great question to say. You want to talk to your estate plan, your financial advisor, and engage your estate planning attorney, because we have lots of opinions on it. But then you can, to another question, engage Baird Trust. Our minimum asset size, there's a question here, it's $2 million, but we love to say we have such a great leadership team at Baird Trust. They consider each case that your financial advisor brings to us on a case-by-case basis. So don't be bound by that number. Just talk to your financial advisor and talk to your estate planning attorney. And there are lots of responses to what we think will happen next. so we can all come to the table and talk about it together if you engage Baird Trust. We appreciate your time. And Corbin, I'll turn it over to you.
Thank you so much, Corliss and Will. Fantastic job today. And so I'll just wrap us up quick. Just thank you both again. I hope that everybody on this call found this information impactful and a good use of your time. For those of you who would like to review today's presentation or share it with a friend, family member, or colleague, the session has been recorded and will be made available in approximately a week through your Baird Financial Advisor or via bairdwealth.com. If we were not able to address your question or you would like additional information, please reach out to your Baird contact and they will connect you with the appropriate resource to get your question answered. Once again, thank you everyone and enjoy the rest of your afternoon. Take care.
Thanks a lot, everybody.